Welcome to the TheMediaWard podcast. The Supreme Court of the United States is the highest court in America, and it's an odd mix of open and transparent and mysterious and secretive. It bounds into world news when they take cases about elections, abortion, gay marriage and other hot-button topics, but today we're going to examine the workings of the Supreme Court with something altogether less headline-grabbing. Fish. Specifically, 72 19-inch long red grouper fish. Cases that end up in the Supreme Court generally start out at a local court, in this case the United States District Court for the Middle District of Florida. They then move up through the appellate courts before finding themselves in the Supreme Court. But before we get to any of that, let's fill you in on the details of the case. The year is 2007, and commercial fisherman John Yates, alongside his small crew, are fishing for red grouper in the Gulf of Mexico off the Florida coast. Yates's vessel, the Miss Katie, was boarded at sea by State Fish and Wildlife Officer John Jones. While he was a state officer, he was exercising power as a federal officer as well. A small detail, but it's important for what comes later. Upon boarding the boat, Officer Jones notices 3 fish that appear to be under the legal size limit. Federal conservation regulations at this time deem that any fish caught that are under 20 inches in length must be immediately released. These 3 fish appear to be under that limit. Officer Jones then spends the next 4 hours examining each and every one of the 3,000 red grouper that Yates has caught, and determines that 72 of them are substantially under the 20-inch legal limit. At this point, Officer Jones issues a civil citation on behalf of the state of Florida, puts those 72 undersized fish in wooden crates and orders the fisherman to preserve them and bring them back to port. The next day, the Miss Katie returns to port and Officer Jones, along with a number of other agents, inspect the preserved fish. Upon inspection, there are now not 72 fish, but 69 fish, and whereas the inspection to sea had measured these fish at between 18 and 19 inches, these are now all between 19 inches and 19.5 inches. There's something fishy going on here. I'm not sorry. Anyway, suspecting foul play, Officer Jones and his colleagues interviewed Yates and his crew. One crew member, a Mr. Thomas Lemons, claimed that his captain, Mr. Yates, had ordered the original 72 fish to be thrown overboard and be replaced with larger specimens. Yates then allegedly told his crew to maintain that they were in fact the original fish. In the initial case, Yates disputed these facts, but later these denials would disappear, so let's take it as a fact that he ordered the dumping of the original fish. 3 years later, Yates is charged with destruction of evidence to impede a federal investigation. At trial, Yates claims that he didn't dispose of any fish, and that Officer Jones incorrectly measured the fish. He claimed that the method of measuring the fish was inaccurate, as Officer Jones measured the fish with their mouths closed. Yates claimed that if he'd measured the fish with the mouths open, they would have been over the legal limit. The government offered an expert witness, Dr. Richard Cody, a research administrator with the Fish and Wildlife Research Institute. He was not actually called during the trial, but his testimony would have stated that the average group of fish measured between 3 to 4 millimeters long with its mouth open, not enough to make a 19-inch fish a 20-inch fish. Yates did in fact call a different expert witness, William Ward, who testified that groupers would appear longer with their mouths open and they would shrink when stored on ice. The government, on cross-examination, cast doubt upon the character of Mr. Ward, questioning him on his own state and federal fishing violations. The district court found Yates guilty on the 2 charges, namely, Count 1, knowingly disposing of undersized fish in order to prevent the government from taking lawful custody and control of them in violation of 18 U.S.C. 2232. Count 2, destroying or concealing a tangible object with the intent to impede, obstruct or influence the government's investigation into harvesting undersized grouper in violation of 18 U.S.C. 1519. He was sentenced to 30 days in prison, 3 years supervised release, and had financial and travel restrictions placed upon him. This had further consequences for Yates, as he was now a convicted felon. He was no longer able to fish, as none of the boat owners wanted to risk being hit with a similar federal investigation, so Yates found himself out of work. It's worth noting that the standard procedure for penalising the catching of undersized fish is a fine starting at $500, or restrictions on one's fishing permit. Now, we need to talk about Yates' second charge, 18 U.S.C. 1519, because that is the charge that takes us all the way to the Supreme Court. This charge hails from the Sarbanes-Oxley Act, passed in the wake of the Enron fiasco. Enron was an American energy company that at its height claimed revenues of around $100 billion. However, it turned out that they were engaged in some creative accounting practices, and the outside auditors that should have kept them in check failed to do so. When this all emerged, the markets went crazy, investors lost a load of money, and faith in the financial markets faltered. The Sarbanes-Oxley Act was pushed through to close some of the legal loopholes which the Enron scandal had unearthed, and to try and restore investor confidence. Section 1519 can be described as a general anti-shredding provision, making it a crime to destroy documents to impede investigations into financial fraud. It was put into place because, prior to the act, it was illegal to persuade another person to shred said documents, but not a crime for you to do it yourself. Conviction under this section carries a penalty of up to 20 years in federal prison and was intended to act as a severe deterrent in the world of corporate financial fraud. Yet, this is the statute under which our fisherman, Mr. Yates, was charged. Which you know is a bit weird. A few undersized fish and a $100 billion corporate fraud disaster are not the same thing. As a fun little aside, whilst the National Oceanic and Atmospheric Administration, NOAA, were pushing to have Yates charged with the very serious document shredding statute, their Director of Law Enforcement, a Mr. Dale Jones, was embroiled in his own document shredding scheme. In 2010, the Commerce Department prepared a report that concluded that NOAA had created a highly charged regulatory climate and dysfunctional relationship between NOAA and the fishing industry, and caused fishermen to feel as though they are being treated like criminals for non-criminal issues. During the investigation, Dale Jones approved the destruction of around 75% of the files at his agency's headquarters. In the wake of this, he got a promotion, while Yates got a felony conviction. Yates appealed his conviction in the 11th Circuit Court of Appeals on a number of issues. Firstly, he argued that the government had failed to provide sufficient evidence that the fish he had ordered thrown overboard were in fact undersized. Secondly, Yates argued that the wording of the statute under which he was charged, specifically the term tangible object, did not apply to fish. In an alternate argument, he argued that the statute is ambiguous and therefore the rule of lenity should apply. The rule of lenity is essentially a rule that if a statute is ambiguous, then the outcome should be to the benefit of the defendant as opposed to the government. Last but not least, Yates argued that the district court had abused their discretionary powers by precluding him from calling a specific witness. As you may have surmised, the appellate court did not agree. As for his claim about calling the witness, he tried to call him at the wrong time, so it violated standard courtroom procedures. No dice. In regards to the government not being able to prove the original fish were undersized, they denied this claim as well. Yates had, back on the shore, admitted to the agent that he had at least a few undersized fish. Yates ordering his crew to dispose of them also heavily implies they were in fact undersized. Moreover, the decision as to whether they were undersized was decided on by the jury. On to the part of the appeal that is important to the future Supreme Court case. The argument that the term tangible object does not apply to fish was rejected, as the basic meaning of the word tangible is perceptible by touch, and that definition clearly does apply to fish. The alternate argument, that of lenity, was denied, basically under the same logic. The statute wasn't vague or ambiguous. Tangible means tangible. It's kind of hard to argue with the logic. The law in question applies to anyone who knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object. It seems a little odd that Yates was charged under this particular corporate fraud law, but according to the wording of said law, he appears guilty. Well, let's see what the Supreme Court has to say on the matter. Before we carry on with the case, let's have a quick explanation of how the Supreme Court works. The Supreme Court is the highest court in the American legal system. When they decide a point of law, all lower courts in the country are required to follow that decision. This is called precedent. The court itself is made up of a Chief Justice and 8 Associate Justices. Each justice has lifetime tenure, meaning they have a job for life unless they are impeached. However, this has only happened once in the court's history. This is supposed to put the justices above political pressure and impart a level of non-partisanship to the court. In practice, however, this isn't quite so true. When a position comes up on the Supreme Court, usually through death or retirement, the sitting president and the Senate select the new justice. This inevitably leads to justices who reflect the political leanings of the administration of the time, meaning that you generally get some conservative justices and some liberal justices. As for the cases that the court hears, discounting the very small number of cases that arrive at the court through esoteric legal channels, the vast majority of the cases before the court are dealing with resolving interpretation of federal law or the Constitution, reviewing a lower court decision that appears to go against a previous Supreme Court decision, when two or more appellate courts come to different decisions on a question, known as a circuit split, or correcting an egregious departure from the usual course of judicial proceedings. In other words, if a court makes a truly ludicrous decision. The Supreme Court will often be in the headlines when cases concerning controversial topics such as abortion or voting rights come before it. The decisions in these cases are generally portrayed in the media as the court deciding a broad moral question, but that isn't the case. The court makes decisions on specific legal questions. These do on occasion have rather far-reaching consequences, but that is not the primary concern of the court. The court, in fact, usually tries to keep its decisions as narrow as possible, and that is most visible in the court's numerous, and often humorous, absurd hypotheticals. The justices will pose these to the lawyers arguing the cases to test their arguments, and point out some of the potential real-world effects of a decision on the legal question at hand. So, how does a case get to the Supreme Court? Well, almost all of the time, it doesn't. The Supreme Court receives around 7,000 applications every year, but their strict selection criteria mean that they only hear around 100 cases per year. To begin the process of maybe getting in front of the justices, you need to submit a certiorari petition. The legal system loves Latin. Certiorari means to be made certain. It's generally just shortened to cert. Pronunciation is also somewhat contested, even between the justices, so let's just stick to cert. So the lawyer submits a cert petition, stating why they feel that their case is worthy of being accepted into the court. The justices all have a number of law clerks who trawl through the mountains of petitions and hand over the more reasonable of the certs to the justices. They in turn vote on whether to hear the case, and if 4 of the 9 justices want to hear it, cert is granted and the case is scheduled for oral argument. Both the petitioner and the respondent filed briefs, and often outside parties also filed briefs, giving their opinion. These briefs argue their viewpoint on the question at hand and the law surrounding it. The petitioner also needs to submit a QP, a question posed, where they distill their cert petition down to one or a few direct legal questions they're asking the court to decide upon. There's a whole heap of paperwork and procedure, but this is niche enough as it is, so let's leave that be. Let's take a look at the questions posed in our fisherman's case. The first question is whether the language of the 1519 section of the Sarbanes-Oxley Act, specifically tangible object, applies to fish, and whether Mr. Yates was given notice of that fact. The second question is whether the appeals court decision to dismiss Yates' complaint about not being able to call the witness was appropriate. The case was only accepted on the first question. Now, this does all feel a little bit ridiculous. The Supreme Court of the United States, the highest court in the land, choosing a case about undersized fish over the thousands of other cases that have petitioned for the court's attention. Whilst this particular case does indeed revolve around an inch or two of fish, the ramifications are much more significant than you might initially think. This case delves into the heart of weighty issues such as government overreach and a statute that may be being used in a wholly inappropriate manner. It's a ridiculous case that brings to the court a vitally important legal question. Now we arrive at the main event, the oral argument. The lawyer for the petitioner, representing Yates, and the lawyer representing the respondent, in this case the United States, each get 30 minutes to state their side of the case. The petitioner goes first, stating their case and answering questions from the justices. They generally won't use all of their time, as after the respondent has stated their case, the petitioner can use their remaining time to rebut some of the arguments of their opponent. We'll be right back after a quick word from our sponsors. Finding good, high-quality, natural dog treats is not always the easiest thing to do. Thankfully, poochiepacks.co.uk has got you covered. Poochiepacks has a dizzying array of all-natural treats for your canine friends, from wild boar strips to salmon sausages. My German Shepherd, Jax, is rather partial to the fish skin cubes. They even offer a monthly subscription service, so your pooch can get the highest quality treats straight to your door. Poochiepacks offers home delivery throughout the UK and free delivery on all orders over £25. For 5% off, and so they know that I sent you their way, enter the code WARD at checkout. That is Ward, W-A-R-D. You can find Poochie Packs at poochiepacks.co.uk. That is P-O-O-C-H-I-E packs.co.uk. Right, back to the show. Today we have one Mr. John L. Badalamenti, an Assistant Federal Defender representing Yates, and Mr. Roman Martinez, an Assistant to the Solicitor General, on behalf of the United States. Let's get to it.
Mr. Chief Justice, and may it please the Court, the natural, sensible, and contextual reading of Section 1519 is that the phrase record, document, or tangible object is confined to records, documents, and devices designed to preserve information. A strong textual indicator that Section 1519 is confined to record-related offenses is the inclusion of the unique term makes false entry in, which Congress only uses in record-related statutes.
Now, whilst each side has 30 minutes, they will not actually have 30 minutes to state their case. The justices will, in short order, interrupt. So the practitioners of the court waste no time in explaining their best arguments.
Not only in 1512c1, but there are, I think 5 times in 1512 from a prior enactment, this same kind of phrase is used, which is record, document, and other object. And you say that we should treat that phrase, as it exists many times in 1512, differently from this phrase in 1519 because of the difference between tangible object and other object. And to me, it seems like other object is, if anything, a more classic case of that canon that I can't pronounce the name of. A justem whatever. And good. That's what I count on my colleague for. I deserve that. But to me, it seems like a more classic case. So I guess I just don't understand why you're treating the two differently.
There's the first interruption from Justice Kagan. She raises a good point. In another related section of the law, the phrase tangible object would indeed apply to a fish. So she's asking Mr. Badalamenti why there would be a difference in interpretation. Once again, the legal system loves Latin. Justum generis, meaning of the same kind, is the idea that general words only encompass similar objects to those mentioned in context. For example, if a law applies to cars, trucks, tractors, motorcycles, and other motor-powered vehicles, we would not take motor-powered vehicles to include aircraft, as the other vehicles mentioned in the list are ground-based. This is also a good example of the tone of the court. For all the rules and robes and seriousness, there's also a fairly friendly back and forth between the justices, and it can be quite informal.
So suppose the fisherman took pictures of the fish, and then he destroyed both the pictures and the fish. It seems very odd that you can throw away the fish without violating the Act, but you can't throw away the picture.
Although it's not what Congress intended, it's what requires that this statute read, even under our interpretation, which brings up the absurdity of this particular case. This underscores everything about this case that's absurd, is that the prosecutor used this statute in this way. And had he thrown a piece of paper overboard that had the day's catch logs on it, that would have been covered. And we concede that that would have been covered.
Well, then why is that absurd? If you concede that that would have been covered, the catch logs, and the prosecutor is trying to do the exact same thing, it's just that he's thrown over a different piece of evidence, why is that such a crazy outcome?
It would be just as absurd to give him 20 years, though, wouldn't it?
It would be extremely absurd, Justice Scalia.
I don't know.
As you can tell, whilst the justices have mutual professional respect, that doesn't mean they won't publicly disagree. Justice Kennedy raises an interesting point when talking about the photos. It is a little ridiculous that photos of an object could receive greater legal protections than the object itself. This exchange between the justices and the lawyer really probes the logic of both the statute as it is and the potential interpretation of the statute if the court rules in the petitioner's favour. In my opinion, however, the late Justice Scalia cuts to the root issue of this case. This statute was not the one Yates should have been charged under.
You have this incredibly broad nexus to any federal matter within the jurisdiction of the United States. What could a matter be, as the amicus briefs point out, any of 300,000 federal regulations that the federal government has placed down upon the American people?
And what is your view, given what you've just said, of the best way to narrow this statute?
The best way to narrow this statute, Justice Breyer, is to interpret tangible object in the company it keeps. And that is a device that is designed to preserve information such that if that device is destroyed, the information contained on that device is destroyed.
Justices will often directly ask the lawyers involved how they would resolve the perceived issue with the statute. Mr. Badalamenti laments just how far-reaching and broad the statute is, if it is read in the way that the government is interpreting it. The government is reading this law, wrapped up in a corporate financial fraud statute, as allowing for charges to be brought against anyone who destroys evidence in any matter related to any of 300,000 federal regulations. His suggestion is to keep the reading of this law in line with the rest of the statute, to keep it related to corporate fraud-related document shredding. This wouldn't mean that Congress couldn't pass a law criminalizing all kinds of destruction of evidence. It just means that this particular act isn't it. The petitioner has finished their initial argument and has chosen to pass the proceedings over to the respondent, reserving some of his time to rebut the respondent's arguments.
If there are no more questions, I'd like to reserve the remainder of my time for rebuttal, Mr. Chief.
Thank you, counsel. Mr. Martinez?
Mr. Chief Justice, and may it please the Court, Section 1519's key phrase, any record, document, or tangible object, unambiguously encompasses all types of physical evidence. That's clear from the standard meaning of those words in ordinary speech and from the broader statutory and historical context in which those words appear.
Why are those the key words? Why don't you start earlier? Don't we alter, destroy, mutilate, conceal, cover up, falsify? Those are certainly pertinent in analyzing the reach of tangible object, aren't they?
I think they show that Congress was intending to essentially figure out every way that someone might imagine tampering with or destroying or obstructing justice by getting rid of evidence. And so they might shed light on it, but the issue in this case is the meaning of the phrase any tangible object.
Well, we know where Chief Justice Roberts stands on the matter. Sometimes justices will ask questions that are really opinions disguised as questions. The justices don't need to just consider their own opinion, they need to potentially persuade the other justices to side with them. Aside from showing his position is also a very valid point. Tangible means tangible, and whilst the way the law treats words is not always entirely in line with how they're used in general language, it is supposed to align as often as possible.
And I think just to emphasize the textual point, it's a very unusual and I think it's highly implausible to believe that Congress chose this broad and expansive phrase, any tangible object, when really what it really wanted to do was refer only to a very narrow and specific category of information storage devices.
Part of the justice's decision-making process is to consider what was intended when the law in question was drafted. Mr. Martinez's argument here plays to that consideration. In another portion of the oral argument, it is questioned whether Congress would hide such a far-reaching provision in a statute aimed at corporate fraud. Two sides of the argument pointed firmly at the one consideration, that of intent.
Is there any other provision of federal law that has a lesser penalty than 20 years that could have been applied to this captain throwing a fish overboard?
Well, Your Honor, he was convicted of violating 2232. The statute that petitioner agreed he could have been charged with, 1512C1, also applies a 20-year penalty. But I'd like to address...
And that's it. There's
the government
nothing lesser than that.
I'm sure there may have been other...
You know, frankly, you come here and yeah, he only got, what did he get, 30 days or something?
Yes, Your Honor.
But he could have gotten 20 years. What kind of a sensible prosecution is that?
Your Honor...
Is there nothing else Who do you have out there that exercises prosecutorial discretion? Is this the same guy that brought the prosecution in bond last term?
Sometimes the justices will be jovial and joke around a little with each other and the practitioners of the court. Sometimes they'll eviscerate them. a little explanation of what Justice Scalia is referring to in regards to the Bond case. Bond refers to a previous case that the court heard that ended with a 9-0 reversed and remanded judgment. In that case, the Chemical Weapons Convention Implementation Act of 1998 was used in a simple assault case where the defendant put chemicals on the doorknob of her husband's mistress, causing a minor burn that was easily treated with water. A pretty clear case of inflating charges to an absurd level, potentially similar in nature to one possible viewpoint in our case.
You charged two offenses, 2232, and Yates is not questioning the applicability of that. Is there any guidance that comes from justice to prosecutors? I mean, the code is filled with overlapping offenses. So here's a case where the one statute has a 5-year maximum, the other 20. The one that has the 5-year clearly covers the situation. Is there anything in any kind of manual in the Department of Justice that instructs U.S. attorneys what to do when there are these overlapping statutes?
Your Honor, my understanding of the U.S. Attorney's Manual is that the general guidance that's given is that the prosecutor should charge, once the decision is made to bring a criminal prosecution, the prosecutor should charge the offense that's the most severe under the law. That's not a hard and fast rule, but that's kind of the default principle. In this case, that was Section 1519.
Well, if that's going to be the Justice Department's position, then we're going to have to be much more careful about how extensive statutes are. I mean, if you're saying we're always going to prosecute the most severe, I'm going to be very careful about how severe I make statutes,
Your Honor,
or how much coverage I give to severe statutes.
Justice Scalia reminds the court about the far-reaching consequences of this case. It's not just a case about a fisherman. Any decision will set a binding precedent, so the decision in this case will affect any number of future cases in the lower courts. This also brings up the conflict of interests faced by practitioners of the court, primarily on the side of the government. Mr. Martinez is representing the Department of Justice, who will be back in the court on other cases very frequently. But the arguments he puts forth in this case may have negative effects on future cases argued in front of the justices. The government can take opposing positions in different cases, but the justices remember that and will absolutely consider it.
To emphasize what happened here, Mr. Yates was given an explicit instruction by a law enforcement officer to preserve evidence of his violation of federal law. He directly disobeyed that. He then launched a convoluted cover-up scheme to cover up the fact that he had destroyed the evidence. He enlisted other people, including his crew members, in executing that scheme and in lying to the law enforcement officers about it.
You make him sound like a mob boss or something. I mean, he was caught. The fish were how many inches short of permitted were the fish?
The fish were it varied fish by fish, Your Honor, but we did not. The prosecution in this case was not about the size of the fish.
The Chief Justice makes light of the situation. Fair point is made. This is destruction of evidence, which should probably be punished, but arguably not to this degree. This is also a good example of how the justices will not necessarily take a particular side. Chief Justice Roberts began by supporting and emphasizing the respondent's initial point. Now he's kind of making fun of him.
Your Honor, we do not prosecute every fish disposal case, and we do not. So I think if you were looking for
the point is that you could, and the point is that once you can, every time you get somebody who's throwing fish overboard, you can go to him and say, look, if we prosecute you, you're facing 20 years. So why don't you plead to a year or something like that? It's an extraordinary leverage that the broadest interpretation of this statute would give federal prosecutors.
It is often claimed that the Supreme Court is out of touch, but this shows that they are fully aware of the real-world effects of their decisions. Well, in this case at least. Well over 90% of criminal cases in the States do not end in trial, but instead end in a plea deal, where the prosecutor and the defendant agree to a sentence without a trial, generally negotiating a lesser sentence as a result. The Chief Justice is rightly concerned about how this statute could amplify the power imbalance in such situations.
No, I know, but it's not just influence a proceeding. It is, for example, and here it's obscure, but it means to destroy something in relation to any such matter or case. What matter? In relation to Any matter within the jurisdiction of any department or agency within the United States. What? I mean, somebody comes to the door and says, I've been through this. He passes a piece of paper through the door. It's the postal, and is a postman. He says, please send this back. It's our proper duty to deliver the mail. I say, I hate postmen, and I rip it up. 20 years.
Your Honor, that would not be covered by...
And why wouldn't it happen? It wouldn't happen because you never prosecute it, though I've had my doubts recently.
Your Honor, it wouldn't happen because the statute requires bad intent. It requires the intent to impede.
Yes, I do. I say I hate postmen. I don't want them to find out. And I tell 4 people I finally got even with the postman. I have the intent. And I'm using a ridiculous example purposely, because by using an example purposely, I'm trying to get you to focus on the question of how possibly to draw a line. And if you can't draw a line, it seems to me that the risk of arbitrary and discriminatory enforcement is a real one. And if that's a real risk, you fall within the vagueness doctrine. There's the whole problem spelled out, and what I do not understand is the relation of this case to that doctrine, or how to decide this case.
Your Honor, this case is not related to that doctrine because the petitioner has not made a vagueness argument.
This is a fun little hypothetical, poking fun at the government, but it is just as easily rebuked by the government, though it does show that justices do consider aspects that are beyond the scope of the case in front of them. Now that we've heard from both sides and the justices have asked their questions, the oral argument is concluded and now we wait. The justices discuss the merits of the case and the legal questions contained within, and they then formulate their opinions. When a majority is reached, the Chief Justice, unless they are dissenting, or the most senior justice, assigns a justice to write the opinion. The justice, together with their law clerks, then drafts an opinion and hopefully has the rest of the majority sign off on it. On occasion, there is an even number of available justices, either through empty positions or justices having to recuse themselves from the case due to conflicts of interest. This can lead to a stalemate, in which case the decision from the lower court stands. And now, for the moment you've been waiting for, the result of our case, Yates versus United States. In a 5-4 decision, the judgment of the 11th Circuit is reversed and the case is remanded. Essentially, the Supreme Court returns the case to the lower court with a note attached saying, "You got this wrong, fix it." The majority opinion that sets a binding precedent for the lower courts was authored by the late Justice Ginsburg. She was joined by Chief Justice Roberts, Justice Breyer, and Justice Sotomayor. Before we get into the reasoning behind the decision, let's note that the Chief Justice was in the majority. During oral argument, he appeared to be pretty firmly on the side of the government. Because the decision-making process is behind closed doors, we don't know whether the argument of another justice swayed him or whether he was simply playing devil's advocate in the courtroom. But it does illustrate that you can't always predict how the justices are going to vote. To summarise the points in the opinion, the court concluded that a tangible object within 1519's compass is one used to record or preserve information. Whether a statutory term is unambiguous is determined not only by reference to the language itself, but also by the specific context in which that language is used, and the broader context of the statute as a whole. Identical language may convey varying content when used in different statutes, sometimes even in different provisions of the same statute. The court has decided that tangible object in this case refers to record-keeping related items, and is not to be interpreted in a broader manner. It also does not matter that other statutes use the phrase in a broader sense. The opinion notes that Section 1519's position within Title 18, Chapter 73, further signals that 1519 was not intended to serve as a cross-the-board ban on the destruction of physical evidence. Congress placed 1519 at the end of Chapter 73, following immediately after pre-existing specialized provisions expressly aimed at corporate fraud and financial audits. The court remarks on how this section in question is in the middle of a corporate fraud statute, further highlighting that it was only intended to be a corporate fraud statute. And finally, 1519's title, Destruction, Alteration, or Falsification of Records in Federal Investigations of Bankruptcy, also points towards file keeping rather than fish. With a little hint of humour, they sign off, pointing out that even the title of the statute indicates file-keeping practices, and not fishing. Now, you might have noticed that there were only 4 justices who signed on to this judgment. That's because Justice Alito submitted a concurring judgment. Sometimes justices agree with the result of the majority decision, but might not agree with how they've reached the decision, or they feel their opinion differs enough to write a concurring judgment. Justice Alito furthers a few of the points of the majority opinion, emphasizing how a word needs to be taken in context. The Nocita Associs canon instructs that when a statute contains a list, each word in that list presumptively has a similar meaning. Applying these canons to 1519's list of nouns, the term tangible object should refer to something similar to records or documents. A fish does not spring to mind, nor does an antelope, a colonial farmhouse, a hydrofoil, or an oil derrick. All are objects that are tangible, but who wouldn't raise an eyebrow of a neighbour when asked to identify something similar to a record or document, said crocodile. Call me a nerd, but I do enjoy Supreme Court humour. Justice Alito continues, next, consider 1519's list of verbs. Alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in. Although many of those verbs could apply to nouns as far-flung as salamanders, satellites, or sand dunes, the last phrase in the list, makes a false entry in, makes no sense outside of file keeping. How does one make a false entry in a fish? Certainly hard to argue against the logic there. On the note of arguing against, now we get to the dissenting opinion. The dissenting opinion is authored by Justice Kagan and joined by Justices Scalia, Kennedy, and Thomas. They begin by stating, this case raises the question whether the term tangible object means the same thing in 1519 as it means in everyday language. Any object capable of being touched. The answer should be yes. The term tangible object is broad, but clear. A fish is, of course, a discrete thing that possesses physical form. See generally Dr. Seuss. 1 fish, 2 fish, red fish, blue fish. Referencing Dr. Seuss is an entertaining touch, but deciding that the word tangible means tangible is a perfectly reasonable conclusion to come to. The dissenters continue, as Congress recognised in using a broad term, giving immunity to those who destroy non-documentary evidence has no sensible basis in penal policy. A person who hides a murder victim's body is no less culpable than one who burns the victim's diary. A fisherman, like John Yates, who dumps undersized fish to avoid a fine, is no less blameworthy than one who shreds his vessel's catch log for the same reason. I can't say I disagree. What Yates did certainly should be illegal. And lastly, the plurality searches far and wide for anything to support its interpretation of 1519, but its fishing expedition comes up empty. So there we have it. Supreme Court burns are just as satisfying as Supreme Court humour. At first glance, this case seemed a little bit ridiculous, but when you delve into the details, the issues at stake turn out to be far more ambiguous and significant. It was deemed absurd that Yates could have received 20 years imprisonment for his actions. I wholly agree that it's absurd, but he certainly shouldn't get off scot-free either. This case about a few undersized fish encompassed much wider issues concerning governmental overreach, inflated charges, and mischarging. In the end, this really rather close decision hinged on the interpretation of a single word, tangible. Whilst I agree with the end result, that this corporate fraud law should not be applied in other contexts, it's certainly not as clear-cut as I thought it would be going into this case. I think that's what fascinates me about the Supreme Court. Don't get me wrong, there are some serious issues with the American legal system and with the Supreme Court itself. But if you dive into any case, no matter how dull or self-evident it initially appears to be, there are so many interesting complexities and nuances to be found. If you like the podcast, you might like my YouTube channel. Find it at youtube.com/TheMediaWard. If you want to support the podcast, please rate it, subscribe, or share it with a friend. It all helps more than you might imagine. If you want to be even more amazing, perhaps you might consider supporting me on Patreon. There you'll find ad-free episodes, get access to episodes 2 weeks early, and on top of that, 1 extra episode every season. You'll also get access to behind-the-scenes content from the YouTube channel, such as extended cuts and bloopers. I'd like to thank St. Valentine Music for providing all of the music you've heard in today's episode. For a full list of my sources, please visit the website at TheMediaWard.co.uk. And one last thing. That Supreme Court Justice who was impeached was Samuel Chase. He He was impeached in 1804 on grounds of letting political bias affect his judgments. In 1805, the Senate voted to acquit on all charges, so he was back to the Supreme Court. But yes, the only one that was ever actually impeached, but it didn't seem to really stick.